The Supreme Court won't hear challenge to Illinois' ban on assault weapons and other gun appeals.
This is Dr. David Schein, and welcome to Business Law 101.
SCOTUS refused to take up several Second Amendment-backed challenges to an Illinois law that prohibits so-called assault weapons, such as the popular AR-15 rifle. The surprise ruling means that the Illinois law will remain on the books, at least for now. Surprise because some of the same SCOTUS recently ruled that bump stocks could not be banned by the U.S. Alcohol, Tobacco, and Firearms Agency. This was a device that became infamous due to the mass shooting in Las Vegas. It allows a regular rifle to be fired quickly. The holding determined that Congress and not the ATF would have the power to make such a determination. The ruling also was in contrast to SCOTUS's ruling in 2022 with the case of New York State Rifle and Pistol Association versus Brune. The High Court upheld the Second Amendment right for the public to bear arms in public for self-defense. Therefore, any limitations had to meet a high test, what is referred to as the strict scrutiny test. What that means is if there is a law that limits a constitutional right, like the Second Amendment, it must be narrowly structured to only serve the public good and not impair constitutional rights. The Illinois state law in question made it a felony offense to have assault weapons, including AR-15s. The trigger was a mass shooting that involved an AR-15 and resulted in 7 dead and dozens injured during the 4th of July parade in 2023. It is likely that lawsuits pending against the Illinois statute will continue in the lower courts. The issue seems likely to return to the Supreme Court in the future. Some may ask if further Second Amendment cases against the statute might return to SCOTUS. Why did SCOTUS not review it now? The selection of cases by the High Court is tough. 4 of the 9 justices must agree to hear a case. It must be ripe for consideration. In this case, some of the conservative justices were outvoted. In fact, Justice Thomas stated that the AR-15 is the most popular semi-automatic rifle in the United States and is in common use today. This would seem to telegraph his support for keeping this weapon available to the public. To give our audience an idea of the number of cases decided by SCOTUS each year, over the previous 10 years, the most cases decided was 82 and the least was 47. Think about the thousands of cases that might have been presented to the High Court in that time. This is Dr. David D. Schein. Thank you for joining us for the special episode of Business Law 101. We welcome you to subscribe on your favorite platform.